The Lindsay Clancy murder trial is nearing its end after weeks of testimony. It's been disturbing, as you just heard Rachel say. It's been emotional. It's been revealing. We've heard from doctors. We've heard from family members, investigators, and Lindsay Clancy herself through her texts, her searches, and her statements. And there are a few moments that could stick with this jury. First, the moment Clancy broke down in court as a medical examiner described the injuries to her 5-year-old daughter, Cora. Listen to this. Then there was her internet search history. Jurors learned that before the killings, devices used by Clancy were searching for information about bipolar disorder, mania, suicide, and even can you treat a sociopath? The defense also showed jurors something else, a woman who appeared to know something was terribly wrong, repeatedly reaching out for help.
I'm sad and depressed because I am not able to parent my third child like my first. I want to treat any one of my babies like my first, but I know that's not a feasible possibility.
And the prosecution challenged that image of Clancy, painting her as depressed, not psychotic, they say. And they say that she knew that she was killing her children and that she knew that it was wrong.
She first stated that she took Dawson down to the basement.
Yes.
And then wrapped the exercise band around his neck and strangled him.
Yes.
And what did she say that she said when she did that?
She described that while that was happening, she was saying out loud, "Go to God."
And did she describe the same for both Cora and then Callan?
Essentially, yes. She retained the capacities that were required for having criminal responsibility for these actions. In the household, she was engaging this activity methodically, which highlights to me that there was an ability to conform her behavior to expectations of living in a household.
So after all of this, what will matter most to the jury? I want to bring in our all-star legal panel. We've got Mark Geragos, criminal defense attorney and host of 2 podcasts, Reasonable Doubt and 2 Angry Men. And Jonna Spilbor, she is a trial attorney and also a legal analyst and has a podcast of her own. It's good to see you both. Thank you for joining me. I want to start with you, Mark. What do you think the defense has to do to close things here? And what do you make of this mistrial attempt today and the timing of when it came, when this psychologist seemed to be locked in with the jury talking about this theory that she may have wanted to commit suicide and kill the kids because she didn't want to die without them?
Well, the psychiatrist who, and I agree, at least both you and 2 other observers in the courtroom told me that the juries appeared to be locked in with him. Well, whatever locking in with him was completely undercut by his gratuitous and obviously intentional invocation of the Catholic dogma, Catholic religion, and he provoked that judge. It's got to be one of the top 40 angry judges in front of a jury excoriation that I've seen. And I think this guy did it purposefully. I think he was trying to appeal to the jurors' emotions, if you will, the witness. And I will tell you what I have believed since the first time this happened. I said there is a Supreme Court case. It's rarely utilized or actually applied, Oregon v. Kennedy, and it's when the prosecution is goading, G-O-A-D, the defense to make a mistrial motion. I think they did it before, and I think they did it this time, and I think clearly at this point, Reddington decided, hey, if this guy's getting any kind of traction and I've got to protect my record, I have to make the mistrial motion. And if you listen to what he said exactly that. He said it was intentional, and it was prosecutorial misconduct. You'll also notice that the judge stopped just short of calling out the prosecution as doing it as intentional, because the judge didn't want to be forced into declaring a mistrial and not letting them retry it again.
So why, Mark, you're saying the prosecution wanted a mistrial? Is that what you're saying?
Absolutely. The prosecution knows they're losing. It's clear to anybody who's sentient in that courtroom. So this is their, I'll use the religious imagery, this is their Hail Mary. And their Hail Mary is to get a mistrial, to force a defense to request the mistrial so that they can get a do-over. That's precisely what's going on. Anybody who doesn't believe that or takes issue with that did not watch what that judge did, and specifically where he stopped short when he was going off on this in terms of what the findings he was making, didn't watch how angry he was when he instructed the jury, and most of all, he marched that jury out right after he gave that admonition. He was not going to let them think or hear from this guy again after that stunt that was pulled in his courtroom.
Yeah, and I wonder what they were thinking when the day just suddenly ended early and, suddenly they're marched out of there. Jonna, if the jury believes that Lindsay Clancy was mentally ill, is that enough for an acquittal, or do you think they could believe she had the postpartum psychosis but still come up with a guilty verdict?
It's not enough for an acquittal, but I believe that's what the jury is probably thinking right now. Everyone should probably agree, prosecution included, that Lindsay Clancy did suffer from a legit mental illness and a severe mental illness. I will give her that. The whole courtroom will give her that. But that is not where the analysis ends. The jury now has to decide whether, due to that severe mental illness, she didn't appreciate the wrongfulness of her actions, or she could not conform to the law. And I love Mark Geragos, but I think the prosecution is doing a slightly better job than maybe many of my colleagues think, because they were able to show a level of planning, Brian, that to me, and maybe to some of the members on the jury, does show that she knew what she was doing and wasn't in a quote unquote psychotic break. And for starters, in my opinion, she scheduled her so-called psychotic break when she got her husband out of the house with plenty of time to kill not one, not two, but all three of her children. And that's the first thing that the jurors are going to have to think about when they go back in that deliberation room.
But, Jonna, do you think that this prosecution has had an issue sort of with a cohesive storyline here? Because it seems like at one point they said, oh, she was trying to fake the suicide. Then they have the expert on today saying, no, she wanted to commit suicide and take the kids with her. It's like there hasn't been one kind of story given to the jurors from the prosecution. It's been all over the place.
Well, one thing is for sure, she threw herself out a window. And for optics' sake, that does make her very sympathetic. But the prosecution, in a sense, sort of saved the best for last. We knew that they were going to have to meet the defense expert with an expert who was equally good as the couple of really good experts that the defense had. And I think they did so because the prosecution's last expert gave the jury another set of facts to think about. Was this something that she had planned? In other words, like when you have a case where maybe a spouse kills another spouse in the heat of passion, because if I can't have you, nobody will. They catch him cheating. Well, this was sort of like, if I can't be your mother, then no one's going to be your mother.
Yeah, I just,
what's
again,
interesting, though, Brian?
Yeah, quickly, Mark, go ahead.
You know what's interesting to me? It would not surprise me in the least, and I was the one who last week was calling for Reddington to have asked for a mistrial. Wouldn't surprise me in the least if tomorrow morning he walks in and he asks the judge, he says, look, I made the motion for a mistrial. I don't want to do this again. Your curative instruction, I know what you were trying to do. It's also not enough. I move that you strike the testimony of this witness. I've done that before. I think he may overnight think about that and move to strike the direct testimony of this witness, tell the jury to disregard all of it. It's really quite outrageous what happened today. It's one of the ultimate or the last witnesses, if not the penultimate witness. He directly violated what he knew. This witness is not stupid. He's an expert. He read the previous expert testimony. He was well aware of what the previous expert got admonished for. And for him to come in there and do what he did today, that was intentional. That was misconduct, and it shouldn't be countenance. I will tell you, I think that it polarized the jury as well.
And he said the same thing again, mortal sin. It was the same exact words that got them in trouble the first time. Mark Geragos, Jonna Spilbor, appreciate you both so much for coming on. Thank you.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.